Good day everyone, and welcome back to another episode in our What If series, where we bring you insights in the format of a what if question on the ever-evolving landscape of employment law. My name is Ross Simon from Maserumule Corporate Employment Law, and in today's episode we will be unpacking what if an employee refuses a lawful instruction because it's their birthday. Is dismissal justified? This unusual question came before the Labour Appeal Court in Department of Correctional Services vs. TD Kutu. The employee, who was a correctional officer with 17 years of service, was instructed to escort an inmate with serious medical problems to hospital. The employee refused. His excuse? It was his birthday and he wanted to leave early. When management checked, it wasn't true. Confronted, he changed his story to, it's actually his wife's birthday. Still, he refused. Finally, he said he was going for lunch. In a correctional facility, discipline and safety are critical. Escorting inmates is part of the job. This refusal not only defied authority, it also risked the inmate's health. The employer dismissed the employee for insubordination. The employee sought to challenge the fairness of his dismissal. At arbitration, the Commissioner found the instruction to be lawful and reasonable, and dismissal was upheld. But the Labour Court intervened. The Labour Court agreed that the employee was guilty, but replaced the sanction of dismissal with reinstatement and a final written warning. The court leaned heavily on the employee's 17 years of service and its view that the employee wasn't a problem employee. The employer then appealed against the Labour Court's decision. The Labour Appeal Court overturned the Labour Court's decision and provided three main reasons. First, the wrong legal test was applied. The question wasn't whether a lesser sanction was possible, but whether dismissal was so unreasonable no reasonable commissioner could have imposed it. Second, the employee's record wasn't clean. He already had 3 warnings, verbal, written, and a final written warning, all for insubordination. Therefore, this was repeat misconduct. And third, the court reaffirmed the rule, obey now, grieve later. If an instruction is lawful and reasonable, employees must follow it. If they believe it's unfair, they can challenge the instruction afterwards, following the proper channels and grievance mechanisms. And dishonesty made matters worse. By lying about his birthday, the employee damaged trust, a cornerstone of any employment relationship. The result? Dismissal was found to be fair. So, what are the key takeaways from this case? Long service isn't a shield. It counts in mitigation, but it won't protect employees from dismissal where misconduct is serious or repeated. Dishonesty aggravates misconduct. Once an employee lies, it undermines trust. Once trust is broken, the relationship may be beyond repair. Conspiracies are no defense. The employee claimed management was targeting him. The appeal court held that even if that were true, the employee could have protected himself by simply complying with lawful instructions. The safest course is to comply with instructions and then lodge a grievance. Context matters. In correctional services and similar sectors, refusal to obey instructions can have life or death consequences. This case reminds us that employment relationships are built on trust and compliance. If instructions are lawful and reasonable, employees must follow them, no matter the occasion, birthday or not. That brings us to the end of this week's episode. Thank you for joining us. We hope you have found our discussion informative. If you have any questions or comments, we'd love to hear from you. You can find us on social media, or you can email me on ross@massconsulting.co.za. Until next time, bye-bye.